Welcome back to the deep dive. We're here again to really cut through the noise and get you the essential insights from some pretty complex sources. Think of us as your shortcut to being seriously well informed. Today, we're heading to Trinidad and Tobago, diving into a really fascinating, kind of high stakes legal fight. The source material is heavy going. It's an actual affidavit filed in their industrial court. It's all about a big bank, RBC Royal Bank, sometimes called RBTT, and its security team. But these weren't just any security guards. They were special officers known as estate constables. And here's the core puzzle we're going to unpack. The bank decided these officers were, well, redundant because they lost their special policing status. So they were told, don't come back to work. Seems straightforward, right? A business decision.
Not quite.
Exactly. According to this legal challenge, that whole termination process was so flawed, so tangled up in procedural errors that the officers are arguing they were never actually fired. Not legally, anyway.
That's really the mission for us today. We're jumping into the, let's say, intricate world of labor law. We want to explore that crucial difference between losing a function like the policing authority and actually losing your employment contract. We're specifically looking at claims around two key pieces of Trinidadian law. First, the Industrial Relations Act, that's Chapter 88.01, and second, the big one for this case, the Retrenchment and Severance Benefits Act, or RSBA, Chapter 88.13. That's the law covering layoffs, basically.
Okay.
So the big question hanging over everything is all about procedure. Did the bank actually follow the steps the RSBA demands, especially this critical 45-day notice period? And if they didn't, what happens? Because, the argument here is that failing even one step isn't just a minor slip-up. It's seen as a fatal flaw, one that makes the entire termination null and void ab initio.
Ab initio.
Meaning
Yeah.
null from the very beginning, as if never happened.
Yeah.
This whole case is really a masterclass in how, in labor law, procedure can often be more important than the underlying reason for the decision.
Okay, so let's get into it. Before we dig into how the bank allegedly messed up, we need to understand who these workers were. Their status was, well, pretty unique. It wasn't just security guard work.
Right. This dual identity is key.
And it seems the bank maybe didn't fully grasp the implications when they sent out those termination letters. So first things first, let's establish the basics, what everyone agrees on, the employment relationship itself.
Absolutely. The affidavit makes it very clear. These officers were full-time employees of RBTT. They worked in the Security Operations Department,
And their job.
protecting the bank's property, its assets, standard security function in that sense.
But crucially, who managed them? Who paid them?
All RBTT. They got their salaries from the bank, benefits from the bank, performance reviews, supervision, everything came directly from the bank's Human Resources Division.
So they were firmly bank employees.
Completely. The source even points out the HR address, 1921 Park Street, Port of Spain, just to really hammer home that these individuals were financially and administratively part of this private company, employees. Full stop.
Okay, standard employment. But then comes the twist, this estate constable status. How did that happen?
Right, this is where it gets interesting. About 3 months after they were hired, the bank did something specific. They went through a legal process to, let's say, upgrade their security team's authority.
How?
They applied for and got permission from the Commissioner of Police. This was done under Section 10 of a law called the Supplemental Police Act, Chapter 15.02. This allowed the bank to have these employees appointed as estate constables.
Supplemental Police Act. What does that actually let a company do?
It's a mechanism, really. It allows private organizations, think banks, maybe large industrial sites, big agricultural estates, to have their own security personnel vested with certain police powers.
So it's not just a fancy title. They had real police powers.
Oh, yes. Real state-sanctioned authority. We're talking about the power to arrest people, to conduct searches, to detain individuals. It's significant authority.
Wow. But there must have been limits, right? They couldn't just patrol anywhere.
Exactly. That's the crucial limitation in the Act itself. These powers were strictly confined. They could only be used on the employer's property, so bank premises, or directly in relation to the bank's assets. They weren't general beat cops. They were RBTT's private police force, operating under a public authorization, or a precept.
Okay, so state power, but bank paycheck. That does sound like a recipe for confusion, and this is where the legal argument really kicks in, doesn't it? Did getting this police status somehow make them employees of the state?
According to the affidavit, absolutely not. And this distinction is, well, everything for this case. The Commissioner of Police grants the precept under the Supplemental Police Act. That act lets the function, the authority, be given to the person. But crucially, it does not create an employment relationship with the state. It doesn't transfer the contract. The commissioner isn't suddenly their boss in an employment sense.
So the contract, pay, leave, discipline, how long they're employed, that all stays with the bank.
100%. If an estate constable was late for work, the commissioner of police wasn't involved in docking their pay. That was the bank's HR department. The bank remained the sole employer.
Okay, I think I'm getting it. The bank hires them, then gets them special powers via the commissioner, but the bank remains the employer.
Precisely. And because the bank is the sole employer, the bank is the only entity that can legally terminate the contract of employment. The commissioner can take away the badge, the powers, but not the job itself.
It feels like the bank might have fallen into a trap here, thinking that because the commissioner revoked the policing function, the core part of their role, arguably the job just automatically evaporated.
But that seems to be the assumption they operated under, based on what happened next. And that's exactly where the legal argument says they went wrong. It's like confusing the tool, the police powers, with the person holding it. The estate constable was, at heart, a private employee who happened to have a special public precept or authorization. When the commissioner revokes that precept, which he has the full legal right to do, he's only taking away the special powers.
He's not firing them from the bank.
He cannot fire them from the bank. So after the revocation, what you have is an employee of the bank working in security operations who just doesn't have those special powers anymore.
So the bank still has an employee on the books.
Yes. And if the bank then decides, okay, we don't need a standard security officer in this role, or this role is now redundant, they have to follow the normal process. They have to initiate a formal retrenchment procedure.
Just like they would for any other employee they were letting go because of restructuring.
Exactly. They can't just treat the commissioner's revocation as some kind of automatic trigger for termination. That separation power revocation versus employment termination is the absolute foundation of this whole claim that the dismissal was invalid.
Okay, that makes sense. And it perfectly sets up the next part, what actually happened over those 2 critical days in May 2014. The timing seems absolutely crucial here.
It is. The sequence of events is everything.
Right, let's zero in on that 48-hour period. The affidavit lays out a very specific timeline, and it seems this timeline itself created the legal problem. So, day 1, May 15th, 2014. This is the day of the revocation.
Correct. This is the moment the officers officially lost their estate constable powers. Their precepts were formally revoked, handed back to the commissioner of police. Done.
And we need to pause right there on that date, May 15th.
Yes. Because as of the end of that day, these individuals were no longer functioning as estate constables. The affidavit really stresses this. The revocation removed only the policing authority, their underlying employment relationship with RBTT, legally untouched.
So the bank now has these full-time security staff still on the payroll, still under HR rules.
Still getting paid.
But they can't legally arrest anyone on bank property anymore.
Right. So the bank definitely has a situation. The job description has fundamentally changed. Maybe the salary grade isn't justified anymore. Maybe the specific category of employee is now redundant. That's a valid business issue.
But
Crucially, they still have employees under contract. And if they want to end that contract, they have to follow the formal termination process.
okay. Then comes day 2, May 16th, 2014, the very next day. What does the bank do?
Immediate action. The officers are told, don't report for duty. Termination letters are issued.
And what reason did the bank give in those letters? The affidavit mentions it specifically.
Yes, it quotes the reason, essentially, that their position as an estate constable had become redundant, and therefore their employment was no more needed by the bank.
Okay, so the reason itself, redundancy because the special powers were gone, that sounds potentially legitimate, right? A company restructuring roles.
The reason for redundancy might well be legitimate. That's not really the core of the dispute here. The problem, legally speaking, is the bank's timing and the mechanism they used.
Explain that, the timing issue.
It's critical. By May 16th, when those dismissal letters went out, who were these people? They were not estate constables anymore. They were, legally speaking, ordinary employees of the bank in the security department.
Ah, okay.
So by acting on May 16th, seemingly triggered directly by the revocation on May 15th, the bank essentially skipped a huge mandatory legal step required for terminating ordinary employees due to redundancy.
So instead of saying something like, look, your powers are gone, we think your role is now redundant, so we are proposing to terminate your employment, and here starts the mandatory 45-day notice period.
Exactly. That's what the law requires.
They just said, powers gone yesterday, you're fired today.
Pretty much. They issued dismissal letters to private sector employees because that's what they legally were on May 16th, citing redundancy. And the moment you do that in Trinidad and Tobago, you trigger the full force of the Retrenchment and Severance Benefits Act, the RSBA.
And that act has very specific rules.
Very specific mandatory rules, especially when you're laying off a group of workers due to redundancy. It demands a structured process, consultation, notice periods.
It sounds like the bank treated it more like maybe summarily dismissing a police officer for cause, which wouldn't need that 45-day notice,
That seems plausible.
instead of treating it like a corporate restructuring affecting regular employees, which absolutely does need the notice.
Precisely. They seem to have focused on the loss of the badge, the constable status, rather than the status of the underlying employment contract. And that fundamental misunderstanding, that assumption, is what kicked off this whole legal mess.
It really does sound like a classic case of getting tangled in the specifics, but I want to push on this a bit. Given that the whole point of their jobs seemed tied to that state-granted power, isn't there any argument that the special nature of the role meant normal labor law didn't quite apply in the same way? Why no wiggle room?
Well, the argument presented in the affidavit is that the labor law, specifically the RSBA, is designed precisely to be the safety net for the employee in exactly this kind of situation, provided they aren't, a direct state employee like a civil servant.
Okay.
The RSBA, along with the Industrial Relations Act, governs the relationship between the employer, RBTT, and the person working for them, the Supplemental Police Act. That governs the relationship between the employee and the state regarding those special powers. It's a separate track.
So the bank's duty under labor law doesn't just vanish because the job involved special powers.
Not according to this argument. The affidavit basically says the bank took on the responsibility of employing these specialized personnel, and with that came the obligation to follow all standard labor procedures if they decided to terminate that employment due to redundancy. The law, in this view, doesn't really care why the job became redundant, even if it was a legitimate reason like the state revoking powers.
Yeah.
It cares intensely about how the bank went about severing the employment contract. Was the mechanism valid?
And that mechanism, under the RSBA, demands certain steps before termination.
Absolutely. Strict adherence to procedure, especially timelines, before you actually terminate.
Which leads us directly to the procedural tripwire. The specific failure that could potentially undo the whole thing. The failure to follow the Retrenchment Act itself.
This is the heart of it.
Okay, this is where the legal argument really bites. It all comes down to one specific section of the Retrenchment and Severance Benefits Act, the RSBA, Section 18, subsection 2.
Section 18.2. That's the killer provision, potentially.
Let's break it down. What exactly does Section 18.2 require an employer to do? Because it sounds pretty strict.
It is strict. It says that an employer who is proposing that word is vital. Proposing to terminate workers because of redundancy must give notice.
How much notice?
At least 45 days written notice before the termination actually happens.
45 days, not 1 day, like what happened here.
Not 1 day, 45. And the emphasis on proposing is key. This isn't about telling people after they've been fired. It's a mandatory heads up, a legally required period before the axe falls.
And who needs to get this 45-day notice? Just the employees being let go?
No, that's another critical part. The law specifies 3 distinct recipients for this written notice. First, the recognized majority union representing the workers.
Which in this case was the State Police Association, the EPA.
Correct. Second, the Minister of Labor must receive the notice.
The government itself needs to know. Why?
It serves a broader purpose. It ensures redundancy isn't just a shock decision by the company. That 45-day window allows for potential consultation, maybe negotiation on severance packages, allows the union to engage, and it lets the Ministry of Labor understand the impact, maybe even mediate or prepare social support systems. It's about stability, preventing sudden mass layoffs without warning.
Okay, union minister. Who's the third recipient?
The affected worker themselves, naturally.
Right, so it's a 3-way notification system designed for consultation and planning before the termination date.
Exactly. And the notice itself has to contain specific information. It can't just be vague.
What details are required?
The law is precise. The notice must clearly state, 1, the reasons for the proposed retrenchment, 2, the total number and the categories of workers who will be affected, and 3, the proposed effective date when the termination will actually happen, which must be at least 45 days later.
So everyone involved knows exactly what's planned, why, who's affected, and when it's supposed to happen.
That's the idea. It allows for transparency and a structured process.
Okay. So the law demands this 45-day runway for consultation before the termination. But the bank, as we established, terminated them effectively immediately on May 16th, 2014.
Right after the precepts were revoked on the 15th.
So this brings us straight to the alleged violations in the affidavit. Violation number 1 seems pretty obvious.
Yes. Violation 1. The claim is simply that no 45-day written notice, as required by Section 18.2, was ever given by the bank before they effectively terminated the officers on May 16th.
They just skipped it entirely.
That's the argument. And if true, that's the fatal error. The law says the notice must precede the action. They took the action first. Instant violation.
What about violation 2? How does that follow?
Violation 2 deals with any attempt the bank might have made to notify the minister after the fact. The affidavit argues that any letter the bank might have sent later saying, "Hey, minister, we retrenched these people on May 16th," is legally meaningless for fulfilling the Section 18.2 requirement.
Why meaningless? They still told the minister eventually, perhaps.
Because it's post factum and void. You can't fix a failure to give advance notice by sending a report afterwards. The whole point of the 45 days is the advance warning, the chance to consult before people lose their jobs. Reporting it later completely defeats that statutory purpose.
It really sounds like the bank confused simply reporting an action with getting the necessary legal permission to take the action in the first place.
That distinction is precisely what the legal argument hinges on. And this leads us to the really heavy legal concept here. The idea of a jurisdictional precondition.
Okay, jurisdictional precondition. That sounds important. Let's spend a minute on that. What does it mean for our listeners when a court treats something like a 45-day notice not just as a rule, but as a gate?
Think of it like a critical safety check before launching a rocket. A jurisdictional precondition is an absolute must-do step. If you skip it, the entire operation is considered unauthorized, legally flawed from the outset.
So it's not just a penalty for breaking a rule, it means you didn't even have the right to launch in the first place.
Exactly. In the context of the RSBA in Section 18.2, compliance with that 45-day notice requirement is treated as the legal basis that grants the employer the authority, the jurisdiction, to lawfully carry out the retrenchment.
So if the bank bypassed this step,
Then, according to this legal theory, their action of terminating the employees was done without the proper legal authority. It was ultra vires.
ultravires. We heard that term before regarding the minister. What does it mean here for the bank?
It means beyond their powers. The bank obviously has the general power to hire and fire, but that power is conditional on following the procedures laid down by law, by Parliament. If they ignore a mandatory statutory procedure like Section 18.2, the act of firing is considered beyond their lawful power in that specific instance.
And the consequence of acting ultravires.
The consequence is drastic. The termination, the dismissal letter from May 16th is rendered null, void, and of no effect. Legally, it's as if it never happened.
Wow. That's a huge difference from just, say, an unfair dismissal claim.
Oh, absolutely massive. Unfair dismissal usually leads to compensation, maybe severance pay, maybe damages for lost earnings for a period. But if a dismissal is declared null and void.
It means the employment contract was never legally ended.
Exactly. The contract is deemed to have continued uninterrupted. The person is legally considered to have remained an employee the entire time since the purported dismissal in May 2014.
So they could be owed years of back pay, benefits, continuous service.
Potentially, yes. All of it. That's why the distinction between an unfair dismissal and a null and void dismissal is absolutely critical. It's the difference between a manageable financial settlement and a potentially enormous open-ended liability for the bank.
Okay, that clarifies the impact of the main procedural failure. Now, what about that other sort of secondary issue? You mentioned the defective service claim about the addresses. How does that fit in? Seems minor compared to the 45-day rule.
It is secondary, but it contributes to the overall picture the affidavit is painting. The claim is that the bank's own retrenchment letter allegedly had the wrong HR department address on the header listing 1921 Park Street.
Okay.
And then later correspondence from the Ministry of Labor was apparently directed to a different RBC address, 79 St. Clair Avenue.
So what's the port being made there?
The point isn't necessarily that the wrong address alone invalidates the termination. It's more about reinforcing the argument that the bank was generally sloppy and didn't exercise the required care and diligence during this whole process.
Sort of adds to the narrative of procedural incompetence.
Exactly. When you add it to the major failure, the alleged lack of 45-day notice, it helps build a case that the entire retrenchment exercise was conducted without the necessary precision and attention to legal requirements. It suggests a broader lack of diligence, further supporting the claim that the action was ultra-vires, like they couldn't even get their own address right, let alone the complex legal steps.
Okay, I see. It's supporting evidence for the main claim. So if the bank's action was potentially a nullity right from May 16th, 2014, why is this still being argued years later? Why wasn't it resolved?
Well, that's because the legal process after the dismissal got incredibly tangled up, largely because of this initial alleged failure. It created a whole separate legal labyrinth.
Let's navigate that next. So this whole mess didn't just start with the current affidavit we're looking at. There's a history here. The source mentions a previous attempt to get this resolved in court.
That's right. The very first dispute that arose from these May 2014 dismissals was formally registered with the industrial court. It had a case number, ST0615.
Okay, ST0615. What happened with that case? Did the court rule on whether the firing was valid?
No, it never got that far. The case was actually dismissed
Dismissed. Why?
for want of jurisdiction. The court basically said it didn't have the legal power to even hear the case on its merits.
But why not? It's industrial dispute, industrial court. Seems like the right place.
It seems like it, but here's where the bank's initial alleged failure comes back to bite the whole process. The industrial court, in that ST0615 ruling, found that the Minister of Labor had acted improperly.
The minister, how is the minister involved?
Okay, so there's a process. When an industrial dispute arises, like a potentially unlawful dismissal, it first gets reported to the Minister of Labor. The minister tries to conciliate to find a resolution.
Right.
If conciliation fails, the minister then issues something called a certificate of unresolved dispute. That certificate is basically the official ticket that allows the parties to take the case to the industrial court. Without that valid certificate, the court generally can't hear the dispute.
Okay, so the minister issues the ticket to court. What went wrong in ST0615?
The court found that the minister had issued this certificate ultra vires, there's that term, again, beyond his legal powers.
Why was the minister acting beyond his powers?
Because the court determined the minister issued that certificate without having proof that the bank had actually complied with the mandatory 45-day notice requirement under Section 18.2 of the RSBA back in 2014.
Wait, so let me get this straight. The bank allegedly fails to give the 45-day notice. Then the dispute goes to the minister. The minister is supposed to check if the procedure was followed before issuing the court ticket.
Well, the court essentially ruled that the minister's authority to issue that certificate depended on the bank having fulfilled its prior statutory obligation. The 45-day notice is step 1. The minister's certificate is step 2, leading to court.
And if step 1 never happened?
Then the minister had no legal foundation to perform step 2. He couldn't validly certify a dispute arising from a process that was, according to the court's reasoning in that case, fundamentally flawed from the start due to the lack of notice.
So the court basically threw the case out, not because the workers were wrong, but because the minister didn't have the authority to send it to them, because the bank hadn't done its part first.
You've absolutely nailed it.
Yeah.
The court essentially punished the administrative process for failing to ensure the bank's compliance. It shows how rigidly procedural these things are. The failure at the very beginning tainted everything that followed.
And how does that old ruling, ST0615, help the workers now in this current affidavit?
It's huge for them. They use that ST0615 decision as a judicial determination, basically. Proof established in court that the required notice under the RSBA was indeed missing.
So they're saying, look, a court already found the process was flawed back then.
Exactly, and the argument flows from there. If the minister never lawfully acquired jurisdiction over that first dispute because of the missing notice, then any later attempt to issue a certificate based on the exact same flawed facts must also be invalid. Void ab initio.
The original sin taints everything afterwards.
That's the argument. The legal defect wasn't cured just because time passed. You can't build a valid legal process on a foundation that a court has already suggested was faulty.
Did the ministry try again? The affidavit mentions another certificate.
Yes, it seems there was another attempt. A later certificate dated September 14, 2018 was issued. This apparently concerned a second batch of officers, but arising from the same core events of May 2014.
Did that one make it to court?
No. The affidavit states that this second certificate, even though it was issued by the minister, was never actually filed with the industrial court within the time limit set by law.
Another procedural snag.
And another one, Section Find in Mind all the Industrial Relations Act, puts a deadline on filing these certificates. If you miss the deadline, the certificate effectively expires, and the dispute can't proceed to court based on it.
So years later, the core issue was the firing legal. Still hasn't been decided by the court on its merits because of all these procedural roadblocks.
Precisely. It's been stuck in this administrative and jurisdictional limbo, which is why they're back with this current affidavit trying to force the issue.
Okay, one last jurisdictional point we need to clear up. These officers had policing powers. Doesn't that usually mean disputes go to a special court, not the regular industrial court?
That's a really important question, and the affidavit addresses it directly. You're right, there's often a distinction. In Trinidad and Tobago, Section 2.3 of the Industrial Relations Act says that disputes involving members of the civil service or the protective services, police, fire, prison officers who are employed by the state, go to a body called the Special Tribunal.
So why aren't these estate constables under the special tribunal? They had police powers.
Because of who their employer was. The affidavit argues very strongly. These officers were employees of RBC Royal Bank, a private company. They weren't paid by the government. They weren't hired under the Civil Service Act.
It comes back to the employer again, not the function.
Exactly. The key distinction isn't what they did, policing function, but who they worked for, private bank. The commissioner of police only granted the precept, the authority. He wasn't their employer signing the paychecks.
So because RBTT, a private bank, was the employer,
the dispute falls under the jurisdiction of the regular industrial court, governed by the Maine Industrial Relations Act, not the special tribunal, which is reserved for state employees and essential services.
that's a critical point for them to establish.
Absolutely. It keeps the case in the forum where standard private sector labor law, including the RSBA and its notice requirements, clearly applies. They nail down 2 points. The commissioner couldn't fire them from their job, only revoke the powers. And the bank, being a private employer, means the industrial court, not the special tribunal, is the right place to hear the case about the job, assuming they can get past the certificate issue.
It really feels like the whole strategy is built on using the bank's alleged procedural failure back in 2014 as both a shield, arguing the contract never ended, and a sword, trying to force the system to finally hear the case correctly.
That sums it up perfectly. They want the legal system to essentially press reset back to May 2014 and make the bank follow the rules this time, starting with that 45-day notice.
Okay, so all this detailed history, all the arguments about procedure and jurisdiction, it all leads to a really striking central claim.
It does. It's audacious, really.
The claim is, essentially, because the bank was the only one who could terminate the employment, and their attempt to do so on May 16, 2014, was legally defective specifically, lacking that 45-day notice then, that termination was void from the start. Null and void ab initio.
That's the core legal conclusion they're asking the court to accept.
And the implication of that is just huge if the termination was void.
It means, in the eyes of the law, the employment relationship never ended. These individuals legally remain employees of RBC Royal Bank, Trinidad and Tobago Limited.
Still employees after all these years.
Legally speaking, yes. That's the claim. They are still owed continuous service, which means ongoing accrual of benefits, seniority, and crucially salary for the entire period since May 2014, unless and until the bank goes through the lawful retrenchment process under the RSBA.
Which would presumably involve calculating severance based on a much longer period of service now.
Exactly. Their severance, if lawfully retrenched today, would have to account for all the years they were legally considered employees during this dispute. It shows the immense financial risk of getting that initial procedure wrong. That 45-day process, if followed, would have led to a defined severance cost back in 2014. Skipping it created this potentially massive, open-ended liability.
So given that's their core claim that they're still employees, what are they actually asking the court to do in this specific affidavit? What relief are they seeking? It sounds like more than just asking for back pay.
Oh, much more. They're asking for fundamental declarations from the court to rewrite the legal reality of what happened. There are 4 key things they want.
Okay, what's the first one?
First, Declaration A. They want a formal declaration from the court stating that the alleged termination back on May 16, 2014 was null, void, and of no effect.
So basically asking the court to officially agree with their main argument.
Precisely. This is the foundation. If the court grants this, It judicially confirms the termination attempt was ultra vires, legally invalid. It establishes that the employment survived that day.
Okay. What's the second declaration they want?
Declaration B. Logically flowing from the first, they want a declaration that the officers remain employees of RBC Royal Bank, Trinidad and Tobago Limited.
Making it explicit, you are still our employees.
Yes, affirming their current continuing status. Imagine the impact if the court grants that. The bank would have to immediately recognize them as staff again. It raises all sorts of practical questions. What work would they do? Reassignment. But the immediate legal effect is clear. And typically the remedy involves back pay for the period they were prevented from working.
Right. What's the third declaration?
Declaration C. This one is about cleaning up the messy history. They want a declaration that any past certificates of unresolved dispute or any previous referrals of this matter to the special tribunal are also ultra vires and void ab initio.
Why do they need that?
It's strategic. It prevents confusion or conflict with those earlier flawed administrative steps we discussed. They need the court to basically wipe the slate clean, invalidating all previous attempts to handle the dispute that were based on the same original procedural error. It clears the decks legally.
Okay. Clears the past errors.
Yeah.
And the final thing they want, it's an order, not a declaration.
Correct. The fourth item, Order D, is practical. They are asking the court to direct the Minister of Labor to do something specific.
What do they want the minister to do?
They want the court to order the minister to re-register this whole thing as a new industrial dispute, following the proper procedure under Section 59 Vel 1 of the Industrial Relations Act, and then, crucially, to refer this new dispute to the industrial court for a final determination on the merits.
So they need the court to basically force the minister to issue a fresh, valid ticket to the industrial court, ensuring it gets filed on time this time.
Exactly. Since all the previous paths to court were blocked or flawed, they need a court order to compel the administrative machinery to restart correctly, so the industrial court can finally hear the substantive case likely about the terms of their continued employment or the calculation of back pay and potential lawful severance now.
This whole situation really drives home a lesson, doesn't it? It's specific to Trinidadian law, but the principle feels broader.
Absolutely. This isn't just some legal quirk from the Caribbean. The so what for anyone listening, especially if you're involved in management, HR, or even union activities anywhere, is the critical importance of procedure in regulated areas like labor law.
Procedure is policy.
In many ways, yes.
Yeah.
Here, the bank might have had a perfectly understandable reason to restructure after the policing powers were revoked, but because they allegedly failed to follow the mandatory process, that 45-day notice, the law might completely invalidate their action. The why becomes almost irrelevant if the how was wrong.
And the consequences are severe.
Immense. For a major institution like RBC, allegedly missing a basic 45-day notice turned what should have been a standard calculable severance event into this decade-long legal battle with potentially huge financial exposure for years of back pay. It highlights that when you have employees with complex statuses like these estate constables, you need more diligence in following procedures during termination, not less. The complexity of the role doesn't give you a pass on the basics of labor law. #outro.
Well, this has been a really fascinating deep dive. We've gone into the weeds of corporate risk, Trinidadian labor law, and just how unforgiving legal procedures can be. I think the big aha moment for me is really about that separation of powers and how the bank seemingly conflated them.
Right.
First key takeaway. The employment contract of these security staff existed entirely separately from their special policing powers. The contract belonged to the bank. The powers were just sort of loaned by the state via the commission.
And revoking the powers didn't automatically revoke the contract.
Exactly. That distinction seems to be where the bank's immediate termination plan went off the rails.
And the second big takeaway. That 45-day notice period under the RSBA. It wasn't just a suggestion or a best practice.
No, it was treated as this fundamental gateway, a jurisdictional precondition, as you called it. Missing that step wasn't just unfair, it potentially rendered the entire termination ultra vires beyond the bank's power and legally null from the very beginning.
It really underscores the principle. When you're dealing with laws around redundancy and employment termination, particularly statutory requirements, procedure is paramount. Failing to cross the T's and dot the I's on something like notifying the minister and the union in advance.
Even if the reason for the layoff seems obvious.
Right. That failure can derail everything. Years of legal wrangling, administrative processes thrown out, and as argued here, it can mean the employment contract legally just keeps running.
Which leads us to a final thought, something to maybe chew on after this. If a court does eventually agree with the officers and declares these terminations null and void years after the fact, what does that actually mean for the bank operationally and ethically?
That's a profound question. How does a company suddenly reintegrate or account for employees it considered gone for a decade? Beyond the back pay, what about morale for everyone else? What about the trust in HR procedures?
And maybe more pointedly, if their internal process was found to be so defective in court, how can the bank confidently execute any future restructuring or retrenchment, even if necessary? Does this initial failure create a permanent cloud, maybe requiring extrajudicial scrutiny down the line, potentially hampering legitimate business changes?
It's a real possibility. That one procedural misstep back in 2014 could cast a very long shadow, impacting not just the past liability, but also future operational flexibility. The cost of bad paperwork indeed.
A sobering thought on the long-term consequences of procedural compliance. Thanks for joining us for the deep dive. We hope this gave you some valuable insights. We'll see you next time.